a lot of events in which I normally participate, but looks like today is the start. So, do I
Yes,
have shared access? I can
yes,
pull up
yes,
some
yes.
slides.
So we have our upcoming examination schedule that prompts us to celebrate the day today.
Okay, okay.
Students who are participating in the session, please you may note down your questions and we'll take them towards the end. And you can also switch on your cameras so that our guests can have a look at our joinees as well, our students of SIU School of Business Studies. Yes, you may keep your cameras switched on and keep your mics on mute.
Okay, is it visible?
Yes, yes, it is visible.
It's visible and I'm audible too.
Yes,
So,
audible, visible.
fine, let's go on. So, what we're going to do today is see, we're going to talk, spend maybe probably an hour and a half on different strategies of IP. Okay. Now, when we say IP strategy for startup, does the IP strategy change for startup? That's the first thing to keep in mind. It does. It does because most of the startups are believed to work under certain constraints. Okay. Whereas a mature company with big muscles can take bold decisions. For a startup with competing priorities, there is a tendency to ignore IP. I have been part of several incubation centers, several startup communities, and I find that in many of the cases, IP is not a top priority and sometimes the last priority. It is visualized as a cost, not as an investment. And until they get into an issue where some investor is asking, you get an angel investor or in a B-level series funding, and people ask about IP. So to make it easy, I have divided this slide deck into 5 parts, and hopefully I'll spend very little time in part A because I assume you guys have an understanding of the fundamentals of IP. Now, before we get into the fundamental, the first question is when we say startup, what is a startup? And is it different from any other registered companies? Yes. So the DPIIT, which is the Department of Promotion of Industry and Internal Trade, which is a division of Ministry of Commerce in India, have defined startup in a certain way, which has 4 factors to understand. 4 factors or 4 pillars to hold on to. I thought it is good that we are all on the same page. We know what we are talking about in a startup because sometimes there is an ambiguity on that. So, what is it? First, what is the type of company? It has to be a company which is registered. It could be a private limited company, it could be a partnership or a limited liability company. So, but it has to be a registered company. Age, it should not be more than 10 years old. Following incorporation or registration. Annual turnover should not have crossed 100 crores. Once you satisfy these 3 criteria, the fourth criteria which comes is what is the focus? The focus here is sometimes I find the registration gets difficult. It's more on innovation, development, improvement. You work on a problem, on a niche problem. Today, if I open a grocery shop or a restaurant, I can satisfy the first 3 points. But I'm not a startup. I'm a Me Too company. So I can at the most call myself an entrepreneur, not a startup. So it's very important to do understand that. Now, companies which are formed by splitting or divestition are not considered as startups. And to satisfy all that, you need to get a certificate for startups. This is given by DPIIT. It's an online process. You can register. It's a very simple process. You need to upload certain documents. And if you have a business Aadhaar, it is a matter of minutes. But you need that. That certificate will give you relief in all your IP filings, will give you discount in all your IP filings. Okay. When you claim a discount or a waiver under the startup, you need to file a copy of this DPIIT certificate. Okay. So now I guess we are clear what is a startup. Now, what is IP? Now, IP is just a group of legal rights. Okay. That is provided to inventors, creators for their output. And most of them have commercial significance. So the forms of IP are copyright, trademark, patent, geographical indication, industrial design, integrated circuit, trade secret, plant varieties. Now, I'm not going to go into the depth of them. I assume you know all of them. But I'll spend some time in the first three, copyright, trademark, and patents. For a startup, these are most important, followed by a little bit of design. You will see that in that slide, I have added something in red, which is written as contract. Contract is not a form of IP, not a type of IP, but it is equally and sometimes more important than the forms of IP. See, remember, we are here to take and make IP as a business tool. See that our revenue increases, and all those are controlled by different means which are governed by contracts. So contracts are equally important. Don't ignore contracts when you're dealing with IP. So let's spend some time on the first three, copyright, patent, and all. Just maybe a recap. Okay, what is covered by copyright? Literary works like books, letters, articles, whatever. Dramatic works, musical works, artistic works, cinematography works, and sound recordings. What is the term? It's usually life of the creator, of the owner of the copyright, plus 60 years, or in case it is a cinematographic film or a recording, posthumous work or a government work, it is 60 years from the date of publication. Now, it's important to understand what I put as a key question. Can there be more than one original work? See, copyright is given for original work. Okay? It has to be fixed to a tangible form. Can there be more than one original work? The answer is yes. Copyright is not for the idea, it is for the expression. The biggest example which we encounter this every day is the media and the newspapers. Every newspaper prints the same news, but they all have a copyright on their news. So there can be more than one original work. Now, if somebody has published something or somebody has written the software code, can we use it? It's important to understand the fair use doctrine. That is, yes, we can use it with attribution. Okay. How much can we use? And what are the factors which determine how much we can use? Is based on four factors. One is the character of the nature of use, how much is being used, and what it has the effect on the market. Does it disturb the market of the original mark? These are the four factors courts have always taken resort to. Now, the important question which comes is that how much of I can I use by just giving attribution without taking a license? Rather, for students, how much can I lift from somewhere else, which will be fair use? Okay. This is interesting and important to keep in mind how that if I use for a text, up to 10% or 1,000 words, whichever is less, I can manage without a license, but just by giving a reference and attribution. Okay. That's why you find that most of your assignments, when you check it, return it, and try to keep it as a uh, outer mark as 10%. If it is higher than 10% in your institute, I will suggest it to reduce it to 10%. Similarly, for motion picture, 10% or 3 minutes. For music, it is 10% or 30 seconds, which, this 30-second stuff you will see in many reels and videos that they just give a glimpse, see that it is less than 30 seconds. Photos, you can have 5 works or 10% or 15 works from a collection, database about 2,500 fields or 10%. So if you are using this much, it is free and fair. Now, it is important for startups to understand this because they are going to use all of them in their pamphlets, brochure, websites, and other promotional materials. Or sometimes they may be even taking the use of codes if it's an ICD company. If it is more than this limit, you need to take a license. And the licensing principle is very clear. Okay, the responsibility or the liability lies with the end user. It could be exclusive, non-exclusive, whatever way what you want. Okay, and sometimes we feel that whatever is available in internet is free to use. It is not. It is not. Why it is not? Because it is believed that once you have published something in the net, you have given a license to everybody. Please go to the home page and you'll find there is a button below, usually below, which talks about notices and copyrights. Click there, you'll find what are the conditions for what you need to take permission, for what you need to take license. Most most industrial or commercially active in websites have such details. Now let's get into trademark. Trademark, the purpose is to protect the public so that they get what they want. See, the trademark came in mainly because to avoid the differences of languages or people who cannot read, that they associate it with a brand or a logo and can get whatever they want. And the benefit the trademark owners have is, of course, there's a functional benefit. Uh, there is a emotional benefit with which they connect with their clients, and they are self-expressive. Now, with time, what has happened is these trademarks have become very, very expensive and valuable in terms of brand. Okay. So we hear Google brand is so many billions, or Amazon brand is so many billions. Now those are perceived or calculated values. Okay. Now there is a difference between value and price, which we will see as we move. So value is something what you perceive or you think should be the selling price of it. Price is actually what somebody is willing to pay. You may have a house which you think the value is two crores. You might find that you can only sell it for 1.5 crores. That's the price. So I thought of giving you some active examples where the brands, the trademarks, were actually sold. Okay. When Philip Morris bought the trademark Kraft, they paid $12.9 billion, which is actually 4 times more than their tangible assets. So a trademark or a brand can reach such value. So you, as a startup, you should never be ignoring them. When Nestle bought the brand KitKat from Roundtree, they paid $2.5 billion, which is 5 times the total book value of the company. As an Indian example, when Bajaj and Alliance of Germany found Bajaj Alliance as a joint venture and insurance company, just to use the word Bajaj, Alliance had to pay 72 crores. That was, I think, 15 years ago. So brands do increase value. Now, trademarks can be for device or logo, symbols, brands or headings, commercial names, labels or tickets, like you find a label attached to your jeans, names and signatures, fine, like, names. There are various examples of names, like the Honda motor or, Walt Disney, letters and words, where you have BMW, you have numbers like 555 cigarettes, shape of goods like the Toblerone chocolate, color combination, various logos, and service marks. Service marks are marks which offer a certain service, like the brand or the logo of your institute. They're usually for 10 years, but can be renewed perpetually. If you keep on renewing it for 10 marks, every 10 years, you can have a trademark for as long as you want. Okay, so what is counterfeiting in trade? Trademark? Misrepresentation, okay? Unauthorized production, selling of these, and you have legal remedies like, both civil, criminal, and administrative. Administrative, they can be caught at the customs. Civil is that, you can have injunctions. Criminal is litigation and even jail. As a startup, what should you do? You should monitor the market to see that your brand and your trademarks have been not being misused. You should record it with the customs so that if, see, customers don't need to check only what is recorded there. There's a simple process of recording it, just filling up 2 forms. That it means when a product like that comes or crosses the boundary, the custom will be alert and confiscate it. Okay, you should investigate infringers, and whenever you find a situation, you should send a cease and desist notice. If it doesn't work, go for litigation. Few words about patents. Patents are for inventions. Okay, it's a right given by the government to the owner of the patent. Okay, for a limited period, 20 years, in return to complete disclosure of the invention. It's basically the difference in patents with others is that patents is a negative right. It doesn't give you any right to perform any action. It only stops others from using what you have patented. And they are very territorial. So if you have a patent in India, it is valid only in India. Using that patent outside India, say in UK or Germany, is not a illegal procedure. What can be patentable? Anything new and useful, any process, any machine, any method of manufacture, a composition of matter, or a mixture of all of those, or any improvement thereof. Patentability criteria, it's called the nonce test. Yeah, okay. So it's called the nonce test. So novelty means something new. This new is not new. Okay. You buy a new shirt today, that's not novel. Here, new means unreported and unused in the past. Okay. Utility means it should have an industrial application. Okay. A proper utility, not a throwaway utility. You cannot say a wall. The utility of the wall is to give bricks when it is broken. That may be a utility, but that's not an industrial application. So those kind of throwaway utilities are not effective. It should be non-obvious, means it should have an inventive step. It is not an obvious variation of available prior art, and it should not be in the non-patentable list of each country where you want to process. Every country has a list of which they say are inventions, okay, but non-patentable inventions. It could be an abstract idea or in a way of playing a game, a mathematical method, and some immoral or unethical activities. In the Indian Patent Act, Section 3 deals with such matters. What is infringement in patents? Very, very simple. Make, use, sell, offer to sell. Okay. If you have a patented product or a process, nobody else without your authorization can make, use, sell, or offer to sell them. Any such activity will be considered as infringement. Now, where are the exceptions? The exceptions are, maybe you have the government exemption for certain situation. You have research exception, that is any non-commercial use. Okay. And certain things like, in case of national emergency and epidemic, you can be issued a compulsory license. You have the Bolar exemption. Bolar exemption is doing clinical trials on drugs before the expiry of the innovator patent. And but you're not commercializing. Okay? These are considered as non-infringing activity. So what are the remedies available again? Remember, for trademark and copyright, you can have criminal remedies. That means somebody can go to uh, jail because of the penal code of the BNS, the new BNS. But for patent, you only have administrative and civil remedies. Administrative remedies are very difficult for patents because looking at a product, even at the customs, they cannot know whether it is infringing a patent. The most common remedy is civil remedy, which normally ends up in penalties in case of patents. So administrative remedy can be caught in in the customs. Civil is that you can have both interim and permanent injunction. There's damage to account. Criminal remedy is doesn't require any further explanation. Having finished on those fundamental parts, let's look at some of the strategies for startups. See, it all starts with data. It all starts with information. Okay, it may be experimental or doctrinal. So when you have data, what can you do with that data? There are three main options which most companies involved, including startups. They can publish it. The publish can be written or oral. You can patent that information if it is patentable, or you can keep it as a trade secret. I won't tell anybody. So it is first important is the moment you get a data in a startup environment to decide how I'm going to treat this data and information. On which part of this I can freely publish, which part I must patent, which I can take a chance as a trade secret. Okay? Publish means okay, no, there is uh, no commercial uh, uh, cost involved in it. There's no maintenance, but it has one big advantage, that is whatever you publish, nobody else can patent. Okay, so you are actually creating prior art in that domain. Okay, but it has no, it doesn't give you any right, okay, and it is cannot be reversed. Okay, now you decide some. Not every data, every information needs to be protected. For a patent, okay, you get a 20 years monopoly. It can be used for licensing, assigning. It's a revenue generation thing. Okay, and it's a defensive value. Disadvantage, you need to have a complete disclosure. It's a costly method. It is territorial, country specific, and enforcement requires constant responsible behavior. Trade secret is something which you say, no, okay, I'm going to keep it a secret. Advantage, you can keep it as long as you want. There is no process, no registration, but it is limited to the time you can keep it a secret. As the organization grows, people keep changing organization. If you still want to keep it those things as secret, you should have proper contracts like NDAs, or CDAs being executed, because you may later charge a person, take legal action against a person who has disclosed your trade secret. But the secret is already out. You do not have any right on that information and data. This is the first step which every startup should think, that the information and data I have, which form of IP and what is the distribution matrix that I should follow. Then come some of the practices. Okay. Every organization, mature companies have these systems well established and in place. Startups needs to build them. You should have proper written IP policies. You should have proper procedures for invention disclosure, confidentiality, and ownership. I'll later show you, when the absence of this, how startups have got into difficulties. You should be compliant. That means you should respect others' IP. You should not be infringing somebody else's IP. To do that, you should have a system in place. We'll see how we can build that system. You should have a proper risk assessment. That is okay, fine. Uh, what is the scope of protection? That depends on the IP landscape of your competitor. Should have a proper supply chain management. That is, if you are being supplied with raw materials or subunits of your products, which itself is infringing, then your final product will also be infringing. So one needs to take care of that. Then you need to take care of security, both physical security and electronic and digital security. Look for confidentiality. Now, nobody knows all this. So you need to introduce some training and capacity building. The developer or the scientist in the lab may not be aware that he should follow all this. So it is the duty of the leadership in the startup to infuse those among their employees. It doesn't end there. You should monitor both internally and externally where you stand. And if there are gaps may be there. If there are, violations, you need to have corrective actions. So the jargon which is used in the industry is called CAPA, CAPA. That is actually, first you do a corrective action, that, okay, whatever I've messed up, let me correct it. Second is PA, which is preventive actions. You take measures that this does not repeat again. Okay. Now, why for a startup's IP matters? It matters for four solid reasons. One is competitive advantage. Okay. It places you in a more advantageous position in the rat race of revenue. It attracts investors. If you are looking for investor money and if you don't have any IP properly defined and protected, forget it. In today's world, it's not going to happen unless it's a family matter. Okay, it gives you or it improves your revenue, which could be through your own production or through licensing, cross licensing, etc., etc., and it helps in risk mitigation. Tomorrow, your chance of being sued reduces a lot. These are the most four strategic pillars why IP matters. I've just listed out some of the laws. I'm not going into the detail of this. You can read it later. What are the acts and statutes which are available for those uh, concerning some of the stuff we are talking today. What are the policies which are available? Now, how do we manage this? We often say size does not matter. Size do matter sometimes, but it's a fight between size and quality. That means, do you need to have a big IP portfolio, a large IP portfolio for a higher valuation, for a greater competitive advantage? So big portfolio will definitely give you an advantage. But if the quality in that is not high, at least a sizable portion of that is not high, that portfolio is useless. It's like when you go to a restaurant and order a thali, and the thali gives you some 15 items or 20 items, and all of them are, none of them are tasty. Even if that fellow gives you 20 items, you don't like that thali. But you may go and which gives you only 6 items, and all of them are very tasty. That thali becomes valuable. Same here. Second thing is use a multi-layer protection. That means have several layers of protection, whether it's patent followed by design. If your product is sold in the market which has an appreciation on the look and feel, see that your um, trademarks are also protected. So it's advised to have a multi-layer protection. Third, and the most critical ones which startups ignore the most, do you own the IP? In the excitement of working and the time pressure of coming to the market as early as possible, certain serious documentation processes are often overlooked. There should be proper employee employer agreements. There should be assignments of every IP that has been created or developed to the company. So unless it is everything is owned by the company, it is going to be extremely difficult in the long run. Subsequently, next you should know your market, whether it's not only today's market, it is a little bit, extrapolated. You should know future market also, because that's when your IP is going to be commercialized. You may have an IP, but you still do not have a freedom to commercialize. It's important to do what we call as an FTO, freedom to operate. You should see that there are no blocking IPs owned by somebody else, your competitor, which will stop you from selling or commercializing your product in certain territories. Now, these are exercises which in mature companies happen on a regular basis. Startups need to build them up so that you land up with less surprises as we move towards a more fruitful market. The other thing which I've seen among the founders is procrastination. Okay, they agree they have an IP since its protection takes time or money or effort or external help. It's not that they're not willing to register or protect it. They lose a lot of time, and by that time somebody else comes in. One more thing I have seen among startups, which I'm just trying to put it up here, see, which I've not really put it in a slide, is the founders or the promoters tend to take all decisions, which may not be always a good idea unless you're advised by the right person. Involvement of promoters is good in all decision taking, but solely promoters, mainly in matters of IP, which is a bit complex, may not be always a very correct measure. So, what is the roadmap for a startup? It's ideation followed by development, then launch, growth, scale. Ideation means you get the idea, you start working on it, do the prior art searches, you collect literature, which could be patent literature or non-patent literature in the form of journal articles. Then you make a kind of a timeline and start your development work. At this stage, it is, if possible, file a provisional patent, like grabbing the land. I'll build the house later. You must document all your creations. See that you have a proper NDA with all the people working on it. It could be your employees, it could be your collaborators, it could be your suppliers. Otherwise, tomorrow your ownership issues are going to come. See, when big companies involve me for due diligence or IP audit, these are areas which I find very weak among a majority of startups. Once you have developed, you go to the market. That's the time you file your complete specification, register your trademarks, do all your assignments, okay, and do your freedom to operate search. At the growth phase, you increase your market, go for uh, protection in multiple countries. PCT is a patent cooperation treaty. PCT is one of the routes which are followed and which could give you some relief of deferred cost. You should monitor your competitor. Now, here all, when I say monitor your competitor, I'm not saying monitor the sales, monitor the IP. What is he filing? Is it going to be a trouble for you tomorrow in the market? If necessary, if your business interests are there, you can think of licensing. Do a regular audit. And a scale up things means you're already in a mature market. This is the time when you go after other people, your competitors, who could be possibly infringing your IP. Okay, then you can have assignments, licensing, cross licensing, joint ventures. It's not that you have to do all of them. These are your options. If your business requires, you do it. See, when we talk about IP, remember one thing: IP is primarily governed by technology and law. It is generated by technology, regulated by law. Okay, but when you take any decision, forget technology, forget law. They are all commercial decisions. So all decisions should be governed by commerce, not by technology or law. Technology will build the IP, law will regulate and control that IP, business decisions and other things, or any decision, whether I'll go forward with this IP also, these are all commercial decisions. Now, IP management hierarchy, this is something I took from this book, Edison in the Boardroom, and I suggest that most people who are in startup community or tomorrow going to become startup, it's a very good book to read. Okay. Now, according to that book, they have 5 levels of hierarchy of IP management. First is defensive, which means that I'm not going to infringe somebody else's IP. Make sure of that. Second is I am going to file IP and in a very, very passive manner, controlling cost. Third, I use my IP to generate profit. Fourth, I integrate IP to all functions of the business, whether it's R&D, marketing, finance. No decisions are taken without involving IP or ignoring IP. And the last level is the visionary position where you have reached something like a benchmark. A few words about IP management. It's a very, very simple game. Okay, I call it a game. It's a game between value and risk. And it is very simple in the way the aim is only to maximize the value and minimize the risk. In every IP management step, whatever you take, small, big, it should be aiming at maximizing the value and minimizing the risk. If you maximize the value, your brand value also increases. If you minimize how do you minimize the risk? By near zero violation. You can't say no violation. Sometimes, there are. So we call it a near zero violation and have a proper corrective measure to address it. This is very important for the sustainability of your business. And let's see how you can do all this. So, what is value management? What is the value? As I was saying, value represents the degree of importance or worth, but the price is different. Price is something which somebody is willing to pay. What are the value drivers? Technology, market, and business. And this all, and how do you, when all do you do undertake an exercise of evaluation of an IP? When you are fundraising, investor due diligence, M&A, acquisition, or you are exiting, license negotiation, litigation, dispute resolution, bankruptcy, restructuring, JVs, or for grants from government. These are primarily the time when you do your IP valuation. So value is high, we are happy. Now, how to take care of risk? I try to list down the common risks and what could be the mitigation strategy. Infringement, yes, there could be infringement of two types, outbound and inbound. Outbound is when your competitors are infringing your IP. Inbound, when you are infringing somebody else's IP. So, first case, you monitor, find out. Second case, you do an FTO analysis. Avoid ownership disputes. See that all assignment and agreements are done in such a way that the ownership of the IP goes to the company. There should not be contamination, IP contamination, okay, coming from outside, from third party IP. Okay, it could be or a IP which is separately developed or licensed. There could be trade secret leakages, so you should have NDAs in place. Loss of IP rights, that is, you forget to renew your patent or forget to pay your fees, or, you engage in, you should have a proper alert system, either in house or you employ a IP law firm to take care of this. And to do all that, you must have a governance structure. Okay. I'm proposing a monthly, quarterly, and annual. You may, at the initial stage, a startup may not be able to do all that, but should have some governance structure. Could be half yearly or annual based on the need. Okay. Monthly review, what it shall cover. It's all this review should cover is it should cover the review of the portfolio, not only of yourself but also your competitors. You do an assessment. You see on the revenue, the licensing part, and it is it's a good idea to do proper IP audits on a regular basis. Based on that, your strategy and your valuation will change and involve in the training and of the uh, employees concerned in developing that IP. So, what are the key metrics one should follow? See, if you have a governance structure and if you don't have a matrix, it's not going to work out. Anything which is done, any output, if it is not measurable, and if you don't have a matrix, in the long run, it is going to collapse. Okay, that's not only IP. Here we are focused on IP. So, what are the key metrics you should have? Number of IP filed or granted, budget utilization. In case you have license, what is the licensing revenue? Your competitors' IP activities. What is your compliance score? Your compliance score should be zero. That is, you are not infringing anybody else's or any third party IP. And in case you have done audits, what are your audit findings? You need preventive or corrective actions. So why not need to make a blueprint of management of IP? Okay. So it's again coming down. Some of them may appear a bit repetitive. Okay, it's always see the underlying tone is we need to protect. We will protect. So protect. Can we protect everything? May not be possible. Can we protect everywhere? Going to 197 countries in the world? Because they are territorial. Maybe not. So you need to take a decision in geos and areas where your invention or your IP has a reasonable currency. And then maximize values by the hierarchy chain I have shown you so that it goes to it is part of your revenue stream. Minimize risk by reducing infringement exposures. You should enable growth, okay, by supporting market entry. When your product goes into the market, if it is well protected, then you can have a monopoly in the market. Build competitive barriers. If you have a strong IP, then entry barriers for your competitors becomes high, and you should have a regular due diligence mechanism. See, for any product which is commercialized, the revenue uh, on a particular time and date is fixed. Today, if you look at you know, say Mumbai, the revenue for mobile phone is fixed. There's going to be a sale of this many units of mobile phone, and it's going to generate X amount of money. Now, through IP, what we try to do is if we have a fixed pie through IP, it's not that you are getting an entry, you are keeping others out. If you keep others out, it is most likely that you are going to get a higher share of the pie. If the pie gets distributed among less number of players or a single player, which happens in the initial stage of a pharmaceutical launch, usually for first few years, then you get the entire pie or a maximum portion of the pie. Okay. The entire exercise of IP to generate, protect, commercialize is to get the higher size of that revenue pie. Else, whatever else, these are not business interests. They are only, presentation material. Core business interest is getting the maximum portion of that pie for any, whatever may be your product. If I want to look at the life cycle, it always happens like that. It starts from an idea, you start a research, then you create IP. At this stage, there could be collaborations which requires for extra steps for IP control. Then you may do an assessment, register, then you exploit. Exploitation can be done in three ways. You can do your own production, you can license, or you can assign. Then comes a time of enforcement in the market where you are monitoring. At some day, your IP will expire. So that knowledge is in public domain for anybody to use. This is the overall how the IP life cycle will be moving around. Now, to move from here to here, there are several steps which needs to be done. We'll take a look at them gradually. Now, these are the steps. Now, doesn't mean that every organization needs to do all of these. No, which and when required. Okay. So if you have generated an IP, you can use it for your own production, fine, have profits. You may abandon it, no. If you ignore your IP, it is lost forever. Or you can then, get license or assign it to other utilizers which follow the process. Now, in doing this, there are several short steps which for startups, the idea is not to try and do all of them yourself, get professional help. Now, let's look at what is the startup challenge and what is the investor's view on IP. What do investors really look at? First, they look at market opportunity. How big is my market? Okay. That shows how broad your IP is protected. If it is protected only in one country, my market opportunity is less. If it is protected in registered in multiple geos where I have a strong commercial presence, opportunity is high. Technology strength, it is again, this is a number game. Okay. Investors see how much of IP you have and how and where all you have. Do you have a single patent, a single trademark, or everything is a trade secret? Third is they look at the term team and resource. What is the team which is developing it and what is the team which is managing it? Like any other thing, the last but not the least is what is your go-to-market strategy? If you do not have a clear go-to-market strategy, having IP, with the technologies, with high technology strength, with severe market penetration, it will not work out. So you should know have a clear and a scalable go-to-market strategy. And it is here where IP comes into play and creates the differentiator over your competitors for your go-to-market strategy. So what are the startup challenges now? It is again, the it's in phases. Okay, it until it reaches a steady state. I recommend that it should never reach a steady state. It is always evolving. Now, funding and approval, yes, these are issues in startups, and where there is competing financial requirements with other costs, and they keep your approval cycle as low as possible, as small as possible. Okay, do it in a structured manner. Allocate some budget. Train and have a well developed team. If your developer or your scientist doesn't know that I have to build an IP which should not infringe other existing IP, and for that, what all I need to do, he's just going to waste time and money. So that initial training, I'm not talking about training like a 6 months course. It's a awareness sensitization programs which every organization uh, can take the benefit of. Scale up phase is where you do your protection. Okay, you start your strategic protection, do regular audits. You need not always have an audit done by an outsider. You can have a small team of one or two people who does an IP audit, spends half a day, does an IP audit internally to look at the check and balances which are existing. Okay? At a steady state, you're just enforcing. Things are in a much mature position. You commercialize, you manage. At that time, you can buy IP, you can sell IP, and because of those, you can have a premier pricing, okay? So on and so forth. Now, the challenge again is, it's limited three things: limited budget, limited time, limited knowledge. In a startup environment, you are always rushing and doing multiple activities with you. And there are three things which are limited. Your budget is limited, your time is limited, and your knowledge is limited. So the answer is you can prioritize to have a sensible budget. Okay. You can devote some time, or you can look at for some expertise, develop internally, or get help from external sources for the knowledge part. Because the pressure of development, the pressure of revenue, pressure to get investment will never come down in a startup. We have to live with it. And once we live with it, we have to see how we can do the other activity. It is not that the pressure to develop or pressure to get revenue after 2 years or 4 years or 6 years is going to go. It's not going to go. In fact, it's going to increase. You have to fit your strategy in between that. And why you cannot ignore all this? Because a loss in the IP is a permanent loss, and which could cost you very dearly in dollar terms, I mean, monetarily. And if you are not complying, court cases can drain you and lead to winding up of companies. So you should have all these things, policies, processes, maybe small, build up in your startup. Don't wait for an investor to come. Do his part of audit and due diligence and point out to you that, okay, these are the missing bots. That is going to hit very, very strongly on you. So, what are the key highlights for IP for startups if I look into it? Investors watch your IP. There's no investment in startups where IP has not played a role. The investment in IP should scale with growth. As you grow big, it should scale. You take help of collaborators, partners, or outside law IP firms. Be, be conscious and be selective to get a trustworthy partner. Now, there's no blind rule. Every startup is different. So there is going to be a ad hoc way of proceeding in that startup, which needs to be identified. Just because some other startup in a different domain is doing something, we need not jump and try to do the same thing. Okay? And never leave your IP in steady state. It should always be evolving. Now let's look at our transactions and valuations of the. See, the ultimate aim of most startup is to take it to a phase and then sell it to somebody or have an exit or have a transaction, okay, wholly or somebody to take over. That will require some exercises of valuation, which can lead to proper transactions. So, what are the transactions one can think of when it comes to IP? It could be licensing, assignment, cross licensing, franchising, technology licensing, or JVs. Now, licensing means what? You have an IP. Okay? It is like borrowing books from the library. Okay? You own your IP. You are charging somebody to use your IP under certain terms and conditions, which is it could be exclusive and non-exclusive ones. There are several IP holding companies which hold multiple, okay, millions of patents and have very high revenue stream by just doing licensing. Assignment is going one step ahead, where you do not retain any ownership. It is like selling off. You sell your IP to somebody. You assign your IP to somebody who's interested. Then this is the other part which has become very common cross licensing, mainly in the computing world, is where I license some of my IP to you, and you in return license some of your IP to me. Because we are both caught up and we want to move around. Now, cross licensing usually preferred in areas where the IP held by the two organizations is complementary. And it's not a partnership. There are no business commitments. It is just an agreement to use each other's identified IP, not all. Franchising method has taken a very largely globally, okay, where you give the entire IP, like you have your KFCs and pizza centers and all, where the IP, the know-how, everything is just passed on for you uh, to commercialize under their banner. JVs are okay when two companies gone together and work as a single company. Now, mainly, uh, this happens in both supplementary and complementary IP. Sometimes they get together when they want to build a bigger portfolio IP, or when they get stuck, they want to clear it out. Technology transfer is the most commonest thing which happens. That when most common from institutes, universities, and smaller startups, where they develop a technology which is covered by several IPs, and you transfer it to a bigger player with who has a larger intent to commercialize. Now, whether it is licensing, assigning, whatever, then franchising, technology transfer, these actions or these activities are very, very IP dependent. If you don't have a proper IP, I don't need to license it. I can just follow it the way I want. You cannot come after me. If I don't have an IP, I don't need to transfer your technology. I can just look at your technology, get some idea, reverse engineer it, and use it. So the key everywhere is what is the IP I have? And it's again, quantity versus quality. Now, what you will do, which one you will choose, is based on your business requirement. You may not choose any of them and decide that I will myself go into production, use my IP and create a competitive edge in the market. See, licensing will give you uh, the right to preserve your ownership, whereas assignment, you lose your ownership and it is irreversible. Cross licensing and JVs are more powerful in a bigger business scenario. So a few things about technology transfer. Okay, technology transfer is the commonest thing which happens in the startup community, and there are difficulties, there are challenges. So there are challenges are not only in IP. Challenges are a little beyond IP also. But you cannot just take IP in isolation. So you have IP barriers, okay, mainly on there are several disputes, often on ownership, licensing terms, uh, then blocking IP, somebody third party presence of third party IP which blocks a clean commercialization of your IP. There are regulatory compliance. This is more because more in terms of cross-border transfers. There are contractual complexities, like that's when you're negotiating terms, you can't. It takes time. and a TTA is often long drawn. The valuation disagreements, people don't agree on the value. So these eat up a lot of time. While each of them are important and deserves their merit and time, but it should not be such that you lose the opportunity. Now, the seven easy steps to follow for a technology transfer process is that you start with a letter of intent where you express that you want to, explore this transfer. Then you get into a non-disclosure or a confidentiality agreement where you look at each other's data, IP, and several other things. Once you have done that, then you sign a term sheet, which is a non-binding, but a structure how this is going to go out. Then starts your audit. Now, this audit is going to be technical, financial, IP due diligence. Then, based on the red and green flags which comes out from the audit, there's a valuation which is reached. You negotiate on the terms and condition, and finally, the agreement is executed. Now, your IP is many times much more than you think. Now, your IP, which is your, I would say, your asset inventory, there will be some which is owned by the company. This is the biggest chunk. It could be your patents, your utility models, your designs, trademarks, whatever. And it could be ones which are owned by others. There are third-party IPs once we use. This could be licensed patents, trademarks, some data you took from some library, yeah, or your project has been funded by some government agencies. Yeah. So in those, you should see the articulation of those agreements. Now, there could be now one has to have a clarity that you have the right to use those IPs which are not owned by you. What is the issue? What are the things to be checked in that audit? The geographical scope, the current use, which are the IPs which are not used, access rights, and ease of operation. So for all that, we need records and documentations. So you should have a record of the notebooks, the disclosure forms, all the prior art search being done, clear documentation of ownership for patents and designs. For trademarks, you should have a record of how it was conceived, how it was approved. Remember, when we make trademarks, we often take the help of outside agencies to come out with a final image or figure. No. Now, you should see that they have transferred all the rights to you. Okay. And you should look at all the contracts in this audit, your licensing and cross licensing agreements, in case you have your franchising agreement, joint venture agreement. But in all cases, if those are things, these three which I mentioned, are if you have. What you must have is an NDA with all employees, NDA with all third parties, okay, your suppliers, a material transfer agreement with whoever is transferring any research material, samples, or any proprietary. A consortium agreement in case there's collaborative work. A contract R&D agreement if you have, outsourced a certain part of your development to some other third party. And consultancy agreement for people like me who will come and give you advice. If I given an advice, the agreement should say that it now belongs to the company. So is these are measures which do not happen in one day. It has to be built. It should become the culture of the software of the startup. And during risk assessment, people or investors or the audit process looks at any past infringement cases. If are there any threats outbound, that means uh, any outside uh, third parties are infringing, or inbound, where are you infringing any third party? Is your IP strategy aligned with your business goals? And have you taken the proper corrective actions whenever you found something? Now, valuation has several. There are seven, documented ways of doing valuation of intangibles, and IP happens to be one of them. The three most common ones I have tried to show. One is the cost, market, and the income approach. Cost approach is a very simple approach, usually done in very early stage, where you don't know the market or you don't know the income. It is just how much you have spent on it. Okay. What is the cost? What was the cost to build it, or what will be the cost to replace it? Market approach is usually for trademark, licensing, cross licensing, M&As, JVs, where uh, the approach is to compare the IP of similar assets that are sold in the market. The, the catch here is that you should have an access to those data. Then you need to adjust the differences in scope, territory, and quality. The income approach starts with an assumption that the product is good and it is going to sell heavily in the future, and I'm going to generate an X amount of income. And so the valuation of this IP is going to be accordingly decided. And triggers could be fundraising, Series A to C investors, mergers, acquisition, divestment, licensing, litigation, where if you infringe somebody's patent, what kind of damages you need to pay, joint ventures, or even sometimes for financial reporting to security agencies or publishing in your annual report. IP provisions in technology transfer. When you make a technology transfer agreement, few things about IP should be very clear. What is the scope? Okay. And what are you transferring basically? The ownership of improvements. No work stops. Tomorrow I license or I transfer the technology to you. You improve it. Do I have a right on that improvements? Okay, those should be clearly articulated. Do you have right to sub-license? Yes or no? There are no yes and no. It's all agreement. You agree to it, and for every agreement, there is a price tag. Look at the territory, which is it exclusive or only in certain market areas you can operate? What are your representation and warranties? Who owns? Uh, if there are third-party claims, so reps and warranties and indemnification are to minimize your legal battles in the future. If there is a infringement suit against you, who is going to be responsible and who's going to take the wrath and pay the money? What kind of royalties and payments you are expecting in this technology transfer? It could be a percent of sale, profit, or it could be something like some milestone payments, terms and termination. What are the terms of termination? When it can be terminated? When on termination, it's very important to know what happens to the IPA post termination. It comes into whose control? Okay, this needs to be articulated clearly in the agreement. Confidentially know-how, and in case of dispute, what is the governing law? How are you going to go? Are you going for mediation? Are you going for arbitration or straight litigation? What happens to technology updates? That is the improvements during the process done by either parties. Okay, and are there non-compete clause? And that means do we that we don't compete with each other or we don't compete in this territory, that territory, right? And what are the grant back possibilities? Okay, before I wind up, maybe I'll take a couple of minutes for some practical tools and references. So, common challenges: limited budget, answer prioritize. Lab of expertise, consult qualified people. Infringement risk, do freedom to operate. Early disclosure is this is always an issue because it's not because of always big mouth. Startups need to present, need to talk, file a provisional application. Global expansion complexity, file PCT, take proper advice. Ownership ambiguity, make sure that all IP is owned by the company. Just to give an example, how many types of pattern, what are each of these which a startup normally uses? Uh, Patents for invention, process machine composition of matter, any new technology for 20 years. Trademark protects brand equity, logo, brand name, product name, slogans, 10 years, could be renewed perpetually. Copyright for creative works like, art, design, source code, website content, marketing materials. Trade secret are, proprietary, any proprietary information, it can be business method, formula, pricing, customer list. Hmm. Industrial design for aesthetic looks. Okay, could be looks of your product, packaging, or even your website looks. GI, very few startups you are there unless you are an agri startup or something in that, and then it's less relevant to most of the startups. But in case there are some agri food tech startups or handicraft startups, uh, you can protect it for 10 years. But like trademark, it can be renewed indefinitely. Different type of patents which you can file in India. You can file a provisional. You have a 12-month grace period to file a non-provisional or a complete. In India, we call it ordinary. Then you can file a convention patent within the filing 12 months of your first patent. In all the 152 countries which are members of the Paris Convention, you can file PCT applications. You can file patent of addition in case you file a patent and later on there has been some improvements on the process which you have filed earlier. There you can file divisional patents, which are actually in case there are more than one invention in a patent document that can be divided into multiple patents. Now, for startups, there are a lot of assistance given by the Ministry of MSME. Okay? This is for domestic patents up to 1 lakh, for international up to 5 lakh, trademarks 10,000. This was single ones for both startups and MSMEs. And all you need to do is that you need to just these are all reimbursements, so you need to spend the money, file it online. In that, I've given you the web link also here, uh, through your Udyog Aadhaar, and claim that money. See, this works fine. I've seen people getting reimbursements pretty quick in just a few weeks time. So this is one more thing the startups can use. So one of the key takeaways: IP is not technology, not law. It's a business asset. File early, file often. Own what you can create. Layer your protection. Quality always overruns quantity. IP strategy must scale with time. Use all available support which is provided by government agencies. IP will power your commercialization. And of course, in all of this, you have to prioritize as per your business needs. I think with that, I'll stop now. And probably if there are any questions, I will try to take it, or you may even at some point decide to mail me some of the questions.
Yes, to the audience, thank you so much, sir. It was a very wonderful session. I think you took us through various different aspects that we discussed over the last more than an hour or so. You actually took us through the fundamentals of IP to IP management and IP risk management. And I think the part which was on the IP life cycle and goals of IP management and the investor perspective, that was particularly very, very valuable. And also the startup challenges in, leveraging the IP added sort of a lot of practical significance for all of us. So definitely, this is going to be a very informative session for all of us. And students from all the students are requested to ask, unmute themselves, and raise the questions to Dr. Sarkar.
Sir, it was mentioned that the IP investment should be modest in the beginning. So, is there any generic guideline or maybe recommendation as to how much investment should a startup do at the initial stage for IP protection?
As much as you can. See, see, that's just a typical answer. When I say modest, it means it should increase gradually. See, most of the IP expenses are fixed because you pay normally for registration of any IP as government fees, and government fees are fixed. Now, what is variable is that what you pay to the lawyer fees who gets all it done. Okay, now there are discount schemes in all spheres for startups. What I meant by that is that you don't have to make huge investment in IP in the beginning, but don't make it a point that you have zero investment. You can scale it up with time. There's no figure which you can. It depends on your business type.
Got it, sir. Thank you.
So when we recently have mentioned about the FTO,
Can you please
so
put,
this
yeah, may I know who's raising the question? Can you please just tell your
Sandeep Singh,
name?
yes sir, Sandeep here. So can we know how frequently should a startup
why are
conduct?
you, Sandeep? Why are you hiding?
Please switch on your camera, Sandeep. And Sushmita, I think, was the previous student who spoke from our pharma management program. Can you please switch on your camera, students, please? Yes.
Okay, Sandeep, your question. See, the moment we ask Sandeep to switch on his camera, he's vanished.
Hello, hi sir.
Yeah, Sandeep, what's your question?
So I'm generally asking how frequently should a startup conduct FTO analysis, or is it a one-time event before launch, or it should be integrated into this process of freedom to operate?
No, no, freedom to operate is a must before commercialization. See, it's not that, why do we do it? So that we land up with minimum surprises. Okay, I cannot say zero surprises. So market dynamics will always play its role, and there are blackout times of in IP. If you are not sure that you are not infringing if any other third party IP, the moment you enter the market, he's going to sue you. And to eliminate that is what you do is freedom to operate. That do I have a freedom to operate commercially in this area? Now, FTOs are very territory wise because patents are not filed in that manner. So you may have a freedom to operate in a certain geo, whereas you may not have a freedom to operate in another country. So that exercise needs to be done. It's not a very difficult exercise to do. I mean, it can be done internally in the organization also with some basic training. But there are commercial organizations. If you pay externally, everything can be done.
Yes, does it answer your question, Sandeep?
Yes, ma'am.
And sir, I do have a question. Although you did speak, you talk about the investor purview over in your presentation, but I was just wanted to have some idea about, how do the investors evaluate the startups IP portfolio while they are making these funding decisions? What are the aspects which they actually look at, particularly the IP portfolio? If you can throw some light on that.
So if I understand your question rightly, you're saying that how does a startup manage initially?
No, I'm talking about the how investors evaluate the startups IP portfolio
Oh,
while they are making funding decisions, if they're funding a startup.
see, I actually had a slide on that. See,
Yes, yes.
what they look into that is first is your spread, okay, breadth. So the breadth is that in what all areas you have, this is geos, okay, countries, you have a coverage. Then they go for depth, okay, which is basically a number game. So you have how many IPs in each of those areas which could stop a competitor. Okay. Third is, what is how well you are managing it. So there are cases which I've seen in startups that they filed a patent, but after 2 years, they forgot to pay the maintenance fee, the renewal fee. So once you have that, then they look at these three are established. The fourth thing they look is that what is your launch plan? See, your launch plan depends on your IP primarily because your competitors' IP are not same in different areas. And and even if it is there, the expiry dates may not be same. These are the first four things they look at to start with. Then they will involve somebody to do a due diligence or an IP audit. Okay. And the job of an IP auditor or IP due diligence is just to put flags. They put green flags and red flags in different areas. Now, which is then discussed and mitigated to whatever extent possible. But investors use these green flags and red flags actually for some other purpose also, which is beyond the scope of the audit. They use the red flags and the green flags to negotiate the price. So each flag, once it is flagged, has a price tag or has a risk, which the investors will smartly use to negotiate the final price. I have actually been on both sides of the table on such matters. Um, Once they are clean, okay, that it matches their expectation on depth and breadth, and they see the maintenance, okay, they'll involve a professional group to do an audit. Does that answer your question, ma'am?
Yes, yes, it does. It does. Thank you so much. Thank you so much. Maybe request you to help us with the presentation that you had for an internal consumption, not for any external use. But if you can have your presentation that you made.
I will send it to you in next 10 minutes.
Sure, sure. Thank you so much. Yes, any more questions from the students?
I am. I'll be happy if this session was useful,
Yes.
and thanks for all of you being here. Thank you, Professor Mitra, for having me here. So, bye bye. Have a wonderful evening, all of you.
Thank you so much. Sir, can we just before we sign off, I think I'll request students to please switch on your cameras. We'll have the opportunity to have a screenshot to picture with the guests. Students, can you please switch on your cameras quickly?
हाँ भाई स्विच ऑन करो भाई
Yes, students, please be quick. Yes, I think students, can you please click one image?
Yes, ma'am.
Thank you so much, sir, for your valuable time. It's been more than 1.5 hours today. It was a uh, very intensive, but at the same time, very lucid and comprehensive session we did. And many of the students out here in the as participants today, they have been active members of our institution's innovation council and all the entrepreneurial and innovation-related activities on campus, which are done in support with the IIT and the Incubation Center at SIU School of Business Studies. And we are really happy to have you today for our very engaging session on IPR strategy for startups. I'm sure these students who are the young budding professionals, they will definitely have some food for thought and keep these very useful learnings for their entire future ahead. Thank you so much for your time.
Thank you very much. As I said, if it was useful, I'm happy. Maybe we'll work again together soon. And
Yes.
You can possibly WhatsApp me one of those images which has been taken.
Yes,
I will also keep
absolutely.
it as a memory. Okay.
Yes, absolutely,
Thank
absolutely.
you
Thank
very
you so
much.
much. Have a good day.
You too.
Thank you all. Thank you, students.
Thank you, ma'am.
Thank you, ma'am.
Yeah, ma'am.
Thank you, man.